Do you know where the? Let me go to YouTube. Okay. Let me know when we are live. Oh, good afternoon, ladies and gentlemen. Uh, this is Dr. Olu Asekun again. Welcome to our live podcast. Please invite your friends, family, your colleagues at work. This is another beautiful Wednesday. Our podcast is every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern. That is 10 a.m. Pacific. And currently, that is 7 p.m. Nigerian time. So, you can invite your friend. We are about to start. Today, we are discussing labor certification. Can you please post the topic? We are discussing labor certification today. We have been receiving lately all kinds of questions relating to how people can come to the US legally, especially how employers can sponsor them, what they need to do, what the employer needs to do, what the requirements are, and all of that. Now, let me say this. Labor certification is a mandatory step for most employment-based petitions. So what that means is that if you are going to apply for green card based on employment, 70% of the time, the employer that will sponsor you will need to go through a process known as labor certification. That process is what we are discussing today, labor certification. So the question is, what is labor certification? American government has a responsibility to protect American citizens. And one of the ways of ensuring that protection is to be sure or to ensure that Americans have a job. Now, if the government allow American employers to just bring in foreigners to come and work in the US, one way or the other is going to impact the employment of American citizens. So in order to prevent that, I think I'm sweating. Am I? Maybe because I rushed. Okay, can you please help me turn on increase the AC, please? It was very cold this morning, so that was why I dressed like this. Now it's getting warm. Oh, the heater is on. Yeah, that's why I'm really sweating. Please. Okay, thank you. Apologies for that. Now, the process of labor certification, as I was explaining, before any employer can hire a foreigner, the employer must offer the position to American citizens first. It is only if there are no American citizens who are available or willing or qualified to do the job, that is the only time the employer can offer the position to a foreigner. So, there are a few exceptions to that rule. One of the exceptions is EB1. If you are applying for green card as a foreigner or an alien, the language of the law here is alien, but I've always interpreted it. Alien simply means a foreigner. So if you are applying for green card as an alien of extraordinary ability, meaning that worldwide you have international recognition, you have received a major international award, maybe like the Nobel laureate, maybe major international award. Whenever people are discussing your profession, you must be one of the people they will refer to as the authority in that field. So if you are applying for green card under EB1, then labor certification is exempted. If you are applying for green card under EB2 national interest waiver, labor certification is exempted. In fact, national interest waiver simply means that you have some skills that will make the US government to waive that process of labor certification for you. And of course, if you are a religious petitioner or a religious petition beneficiary, labor certification is exempted. The last but not the least, if you are an investor, if you are rich and you have money, you have $800,000 to invest in the US to apply for green card for you and your family, labor certification is exempted. So those are the only situations in which labor certification is exempted when it comes to employment-based category. But for any other type of employment, it doesn't matter what your profession is, except you are a nurse or you are a physical therapist. For those two, they are called Schedule A occupation. Those two, the US government has already made a determination that those two professions, they are in shortage. If they know that they are in shortage, there is no point telling American employers to offer the position to American citizens first, because they already know that there are not enough Americans in those professions, nursing and physical therapists. Outside that, there is nothing else. You have to go through a process of labor certification. Whether you are an engineer, you are an IT specialist, you are a lawyer, you are a doctor, you are an architect, whatever your profession is, before any American employer can hire you, they will have to offer the position to American citizens first. That is what is called labor certification. Now, this labor certification has specific requirements, specific procedural steps. The first thing the employer must do before the employer can even consider any foreigner, the employer must place advertisement in a major newspaper in the area of intended employment. In other words, if the employer, if the job is located in Dallas, Texas, the advertisement must be in a major newspaper in Dallas. You cannot go and place advertisement in New York Times and then tell immigration that, oh, there are no American citizens who are interested. No, you have to place your advertisement in Dallas Morning News. That is the newspaper that people in Dallas will read. So the employer must place advertisement in a major newspaper in the area of intended employment. Second, the employer must place advertisement in at least three online job search websites. When we say online job search website, we mean that any website that people go to look for employment, especially websites that Americans go to. You cannot go and place advertisement in a website that they use in Russia or they use in Germany. No, it has to be website where American citizens go to look for employment. At least 3 of such. The employer must place advertisement in there. In addition, the employer must place advertisement with the state workforce agency. Every state in the United States, they have what is called state workforce agency. That is where American citizens go to apply for unemployment whenever they are out of job. So the employer must place advertisement with the state workforce agency so that when Americans go there to go and apply for unemployment, they can direct them that, oh, you are a lawyer, Law Office of Olu Asekun is hiring. They have this advertisement. Go there and apply, so that they can direct people who are unemployed to that advertisement. So the employer must place advertisement in a major with the state workforce agency. In addition to that, the employer must place advertisement of the job opening on the employer's website. On the employer's website. Furthermore, the employer must place advertisement in a conspicuous place at the employer's job location. For example, if the reception is the most conspicuous, the employer must place advertisement at its own reception. But some employers have notice boards. So for employers who have notice boards, they must place notice of this job offer on their notice board. Now, everything I've explained so far, they are advertisements. But the job notice that must be placed in a conspicuous place, it must have a different content. In the case of the job notice, the employer must state that, okay, we have this job opening. We intend to offer this job to a foreigner. If anybody have an objection, they should contact the Department of Labor. Their number is this. Their address is this. So that notice of job offer must provide those information so that anyone who believes that the employer should not hire a foreigner, they will have the right information to contact the Department of Labor. This is a mandatory step. On the other hand, for every other advertisement that the employer must place, either in the newspaper, either with the state workforce agency, either with employer's website, either with online job search website, every other advertisement that the employer must place, those advertisements, they also have their own specific requirements. The advertisement must state what the job offer is, the job that is open, whether it's the position of an attorney, whether it's the position of a data processor, whether it's the position of a business analyst, whether it's the position of a pharmacist, whatever the position is, the advert must state what the position is. The advert must state what the salary is, or at least state that the salary is competitive within the industry. So what that means is that whatever is paid for such a position in the industry, the employer is willing to pay it. In addition, the employer must state the name of the employer. You cannot place an anonymous advertisement. Anonymous advertisement will not meet this requirement, because for people who want to apply, they need to know who they are applying to. It is not everybody that wants to work for a particular company. So maybe if a Walmart, for example, advertise, I may have the impression that, you know what, I don't want to work for Walmart. So I need to know who am I applying to. So the name of the employer must be included in the advertisement. Generally, the address of the employer or a contact address or a mailing address for the employer must be included. Now, this is where it becomes tricky. The nature of the job position must be included. The requirement, the minimum requirement for the job position must be included. Now, why did I say this is where it becomes tricky? The Department of Labor is aware that a lot of employers, they place advertisement that will tailor a particular advertisement to meet the need of a particular applicant. Maybe they already have an applicant in mind. Maybe this person has some specific or unique qualifications. Now, when they place that advertisement, they are going to include these unique qualifications in their advertisement. So the Department of Labor is aware that companies do this. So they are going to scrutinize the job requirement. Is this normal in this industry? If it is something that is not normal in the industry, they are going to raise a red flag. Is this even legal? They are going to consider that as well, because sometimes some employers, they will put provisions that are unique to a particular applicant to the extent that that provision may even be illegal. I'll give you an example. Using my office as an example, let's say we have a position for a lawyer, for an attorney in this office, and we wanted to process labor certification. And because labor certification requires that we place advertisement, my office is located in Arlington within the Dallas-Fort Worth metropolis, which means I have to place advertisement with the Dallas Morning News. I have to place advertisement with online job search website in this country. Now, let's say my advert reads something like this. Maybe I already have a friend who is a lawyer, or somebody in mind who is a lawyer that I want to sponsor. I want to file labor certification application on behalf of this person, and I want to ensure that my advertisement will be such that Americans will not be able to apply. Let's say this my friend can speak multiple languages. Maybe my friend can speak Spanish. Maybe my friend can speak German. Maybe my friend can speak French. Now, I now place advertisement that says something like this: attorney wanted. Applicant must have Texas license. That is normal because I'm located in Texas. It's a requirement. If you don't even have a license, you can't practice law. So that is normal. Applicant must have 2 years experience. Yes, as an employer, I may choose not to employ a novice. I may choose to employ somebody that will be useful for me from day one. Because if you don't have experience, you may not be able to be useful for day one. There is no problem with all that. I say competitive salary. I now add that applicant must be able to speak French, because in this office, we have a lot of French clients, and most of the time, we face challenges in getting interpreter. So we want a candidate who must be able to speak French. Contact the law office of Olu Asekun PC, 5020 Mansfield Road, Arlington, Texas, 76017. Or send your resume to info@olufiade.com. If we place that kind of advertisement, on the face of it, there is nothing wrong. I mean, everything I've explained so far, there is nothing wrong with it. But if I submit that kind of advertisement for a labor certification application, the application will be summarily denied. Somebody is wondering, why would such an application be denied? It will be denied because it is illegal. I have included illegal provision in that advertisement. By saying that an applicant must be able to speak French, that is illegal. We are in the United States, we are not in France. So it is not mandatory. It is not a requirement that American citizens must be able to speak French before they can get a job. If American citizens have to make French a requirement, then there's going to be a problem. Nobody will get a job, or a lot of people will be jobless. So this is the United States. We don't speak French here. We speak English here. So it is not a requirement for an American to be able to speak French before they can get a job. So that is a requirement that I put in the advertisement specifically to disqualify Americans who may have been eligible for that position. So that is illegal. So the Department of Labor is going to summarily deny that kind of labor certification application. I've seen government agencies in this country that desire seriously to hire a particular person, and that agency I'm not even sure if it's a government agency. Marisa, can you, MHMR, is that a government agency? I think they are a non-profit funded by the government, but they are a non-profit. About 80% of their clientele, they are minorities. Oh, it's a government. Okay, I've just been reminded that it's even a government agency. Majority of their, about 80% of the people they attend to, they are minorities. So when they placed advertisement and stated that applicant must be able to speak Spanish, it was denied. Even though it's a government agency, it was denied by the Department of Labor. You cannot do that because it is not a requirement for an American citizen to be able to speak a foreign language before they can get a job. So that is one of the reasons why labor certification applications get denied, especially when they are processed by inexperienced attorneys or people who are not familiar with all these technical details. I see that a lot of questions have been coming in. I think I'm going to stop here and start answering the questions because I've seen a lot of questions. Okay. The first question, what are the main reasons a labor certification application might be denied? Well, I think I just answered that. I just addressed that. That's one of the major reasons. If the labor certification application does not comply with the procedures, and the procedures are what I just explained, the employer or the proposed employer must place advertisement in a major newspaper in the area of intended employment, must place advertisement with the state workforce agency, must place advertisement in at least 3 online job search websites, must place advertisement on the employer's website, must place notice of job offer in the employer's principal place of business. And the notice of job offer must have specific provisions. This employer intends to hire a foreigner. We have a job position. They will mention the position, and we intend to hire a foreigner. If anybody has an objection, they should contact the Department of Labor. The Department of Labor's phone number is this. Their address is this. That notice of job offer must be placed in a conspicuous place at the employer's principal place of business. If the employer has a notice board, that notice must be placed on the notice board. If it's an employer that does not have a notice board, then it should be placed in the reception or any conspicuous place that when people walk into that employer's office, they should be able to see that notice. And of course, the advertisement must comply with the law, and that is what I just explained. So all these things are mandatory. So if any of the steps are missed, the labor certification application is going to be denied. The next question, what does PAM stand for? PAM stands for Permanent Labor Certification. Permanent Labor Certification Application. So that's what PAM means. The next question, good afternoon and thank you for joining. The next one, how specific can a labor certification be? I believe I've answered that. I mean, the labor certification is an application. It's not a document. It's an application. An employer has to apply after meeting all the job posting requirements. The advertisement has been placed with the state workforce agency, online, employer's website, online job search, major newspaper. All those things have been done. And at the end of the day, there are no Americans who are eligible for the position or who applied for the position. So thereafter, the employer will submit an application for labor certification to the Department of Labor. Now, once the application is submitted to the Department of Labor can do one of 3 things. They can review the application and summarily approve it. If they believe that, oh yes, this employer has complied with all the laws and everything, they can summarily approve it. They can also review the application and summarily deny it. I've explained one of the reasons why they can summarily deny it. If there is any provision in any of the advertisement that the government or the Department of Labor believe that it is illegal, they will summarily deny it. That's why I gave an example of an employer who put a provision that a particular applicant must be able to speak a foreign language. That is illegal. So that is a summary, that will lead to summary denial. The third thing that the Department of Labor can do, which is why one of the major reasons why a lot of employers don't want to go through this process, the Department of Labor can choose to audit the employer. Now, when they audit the employer, what that means is that they can tell the employer, okay, I'm going to use the example of the law office that I used previously. Let's say we submit, after placing the advertisement, there were no Americans that we believe is eligible for the position, and then we submitted application for labor certification. The Department of Labor can decide to audit us. They can say that, okay, when you place advertisement in Dallas Morning News, how many people apply? We want to see copies of their resume. We want to see copies of their application. Why do you believe they are not eligible for this position? Why do you believe that they are not qualified? Did you even invite them for interview? Did you even shortlist them? If they were invited for interview, how did you contact them? If you call them over the phone, we want to see your phone record. If you send them an email, we want to see a copy of that email. If you send them a letter, we want to see proof of delivery of that letter to the applicant. Remember, part of the places that is mandatory for the employer to place advertisement is state workforce agency. That is where American citizens go to apply for unemployment. So it is possible that when you place the advertisement with the state workforce agency, it is possible that a lawyer who is a U.S. citizen, during the period that the advertisement was running, a lawyer may have approached the state workforce agency for unemployment, and the state workforce agency may have directed that lawyer, oh, you are a lawyer, you don't have a job, okay, go to law office of Olu Asekun, they are hiring, this is their address, this is a copy of their advertisement, go there and apply. One thing you must note is that every unemployment benefit, before you can, one of the requirements for unemployment benefit is that you must show that you are actively looking for a job. So if you tell them that you are unemployed and they are paying you, and now they see an advertisement, they believe that you should be able to get a job. So if you come back the following month to apply for unemployment again, they will tell you, but last month we told you the law office of Olu Asekun is hiring. You are a lawyer, why didn't you apply? If this person actually applied, what do you think they are going to say? They will tell the Department of Labor or the State Workforce Agency, oh, you know what? I applied. When you gave me the information, I applied. I sent them an application. Either the person will say they invited me for interview and they told me that they will get back to me. I never heard from them. Or the person will say they never even called me for interview, but I submitted my application. So the Department of Labor may have had that information because State Workforce Agency, they are under the Department of Labor. So the Department of Labor may have been armed with that kind of information. So when the employer eventually submit application for labor certification and they are auditing the employer, they are going to ask, okay, how many people apply from the State Workforce Agency? Did you even invite them for interview? Why do you believe they are not eligible for this position? And because they already have that information, they already know at least one person who applied, who they believe is eligible. Now you have to give them a valid reason why you think that person is not qualified. So the employer may get into trouble. And guess what? The Department of Labor may ban that employer from ever hiring a foreigner. The Department of Labor can give that employer financial sanction. They can fine the employer, depending on how big the employer is. The sanction could run into billions of dollars in fines. So the employer may be given temporary suspension from participating in job recruitment of foreigners. So a lot of things the government could do. So, and besides, once the government start auditing an employer, once they start asking for your documentation, many employers don't want to do that. They don't want to go through that. Everybody wants privacy. I don't want government in my business. So once you open the door for them to start asking questions, I tell you, except genuinely you did not believe that this person is eligible, except for that, there is no way you will not get into trouble. So that is why most people, when it comes to sponsoring a foreigner, they are reluctant. Most companies, they are reluctant. Even big companies now, because nobody wants to go through all this unnecessary stress when you could just actually hire somebody here locally who can do this job. Why do I need to go through all this if I'm an employer? So that is the number one challenge that foreigners have in getting this labor certification application approved. Let me go further. Please remind me the last question I answered. Because this thing has moved. I think the next one, the next one should be the prevailing wage question. Okay. The next question is, what is the prevailing wage determination and how can it affect the process? I've actually answered this in my explanation, but I will repeat it. Prevailing wage determination means that the employer must offer in their advertisement an amount that is the prevailing in the industry. Again, going back to the example of the law office, let's say my law office is the one that wants to hire a lawyer. So the first question, before you even start the application process, the first question is, how much is a lawyer paid in Dallas-Fort Worth metropolis? So you have to make that determination, because if a lawyer is paid $100,000, for example, and in your advertisement you state that you are going to pay $99,000, it's going to be automatic denial, because it means that you want to pay below the prevailing in the industry. And again, one of the reasons the government don't like that is because once they allow you to bring in a foreigner and pay them less money, a lot of employers is going to go through that route. Nobody wants to lose money. If the prevailing wage is 100,000, if I'm allowed to bring in a foreigner and pay the foreigner 70,000, what do you think I'm going to do? I'm going to go for the cheaper one. Hold on a minute. Can you please help me tell this person that I'm in the podcast? Listen to whatever they want to say. You can step out. So, what the government want to prevent is a situation where employers don't go for cheaper labor from outside the country, because the moment they are able to do that, people are going to start losing their jobs. People are going to start losing their job, because if I'm allowed to go and bring in a lawyer from outside and pay the lawyer 50,000, why would I want to pay 100,000 to an American lawyer? I would prefer to pay the lawyer is a lawyer. They will do the same job. So why would I do that? So at the end of the day, Americans are going to start losing jobs. So that is why the government cannot allow that. So in order for the employer to be sure that whatever the amount, whatever salary they are advertising is not below the prevailing wage, they are supposed to apply for prevailing wage determination before the application process is decided. Did you talk to him? Okay. So that is the position. That is what is called prevailing wage determination. The next question. Can an employee switch jobs or employers while their labor certification is pending? No. If they switch job, the new employer will have to commence the process of the labor certification application, because labor certification application is peculiar to an employer. The employer is the one that is going to show what the job position is, where the job location is, what the payment is. So it is the employer who will go through all of these things. So if you now switch to a new employer, of course, the new employer is going to have to start the process of labor certification all over again for this person. The next question: are there specific challenges for industries or regions with high employment? What do you mean? I don't understand the question. Specific challenges, how? There are provisions. There are provisions in the law for people who are applying from a high unemployment area. They have their own specific requirement. That has nothing to do with labor certification. The next question: who initiated the process with the Department of DOL, Department of Labor? It is the employer. This labor certification thing is by employer. It has nothing to do with the employee. The only thing the employee needs to do in this process is to provide his or her qualifications, credentials to the employer. That's it. This is an employer-based process. It has nothing to do with the employee. How is the employee going to place an advertisement for himself? That doesn't make sense. So it has nothing to do with the employee. This is a process that is exclusively for American employers that they have to go through before they can petition for a foreigner. The next question: how do unions or collective bargaining agreement play into the labor certification process? Well, the interests of the unions are already protected. That is why employers are not allowed to offer positions to foreigners without offering it to American citizens first. I am sure that it is the unions that negotiated that with the government. So the employers are not allowed to petition for a foreigner except they go through this process of labor certification, except they go through this process of offering the position to American citizens first. So it is only when it has been determined that there are no Americans who are qualified or who are interested in doing the job that they can now offer it to a foreigner. And as I said at the beginning, there are a few exceptions. Nursing and physical therapists, they are not required to go through this process. Religious employment, they are not required to go through this process. People applying under EB1, they are not required to go through this process. People applying for EB2, national interest waiver, they are telling the government to waive this process for them. So the question is, what is so important about them that will make the government waive this process for them? And lastly, people who are applying as an investor, people who are applying as investors, if you have $800,000 to invest in the United States and you can explain the legitimate source of your money, you are not required to go through this process. So those are the exceptions to the labor certification process. But for every other employer, they have to go through this process. The next question: how can an employer prove they can pay the prevailing wage for the job? Well, this is after the application has been approved. You can't even start proving that you can pay or you cannot pay. All that does not go into play until labor certification has been approved. So you have to get an approved labor certification first. One thing I want my listeners to understand is that this labor certification application we are talking about, this is not about immigration. This is not processed by immigration. This is processed by the Department of Labor. Although it is part of the immigration process, but it has nothing. USCIS does not get involved. It is the Department of Labor that solved this. It is after the Department of Labor has given the employer the certification. Labor certification means that the Department of Labor has confirmed that there are no American citizens available or qualified to do this job. So that certification is what is called labor certification. So after the Department of Labor has done that, that is when the employer will now start the process with USCIS. So this, up to this point, it has nothing to do with USCIS. This, you are dealing with the Department of Labor first. So it is only after that that you can go to USCIS. So to go back to the question, it is when you are filing with USCIS now that you will now show that the amount that was stated in the labor certification application as your salary, the employer can afford to pay that. So it is at that stage that that question comes in. Now, the employer can show evidence of that either by a pay slip of previous employee in that position. The employer can show it by audited financial statements showing that they have substantial finances to be able to do that. The employer can show it by showing money set aside in a particular account that they intend to use to pay this salary. So there are several ways that the employers can do it. And if the employer is an employer that has a minimum of 100 employees or more, they don't even need to prove anything. In law, there's a legal maxim, we say res ipsa loquitur. The thing speaks for itself. So if you have 100 employees or more, they don't need to start asking you, how are you going to pay for this one person if you have been paying 100 people? So that will not even come into play at all. The next question: how does labor certification impact professionals in high demand field like tech or healthcare? Well, it doesn't affect. The only thing that affects is the healthcare. Like I said, nurses and physical therapists, those are the exceptions, and religious workers and investors, those are the exceptions to the labor certification application. It does not affect, there is no exemption for people in high-tech area. No, there is no provision for that. Everybody has to go through that process called labor certification. The only exception, nurses, physical therapists, religious workers, and investors. Anything outside that, everybody has to go through it. And of course, people are applying under EB1 and EB2 national interest waiver. The next question: what is the purpose of the prevailing wage determination from the Department of Labor? I think I already answered that. The process of prevailing wage determination is to show that what the rate, what an employee in that field is paid. Like the example of the lawyer that I used, if I want to hire a foreigner in this office and I have to go through the process of labor certification, the first thing I need to do is to determine how much is a lawyer paid in this area. So whatever salary that I'm going to offer must not be less than what they pay in the area. So how do I know what they pay? By applying to the Department of Labor. Can you tell me what is the prevailing wage in this area? That is what is called prevailing wage determination. The next question: what happens if the labor certification is denied? Of course, if the labor certification is denied, you can't move further. There's nothing you can do. The employer will have to hire somebody in the country, or hire an American or somebody who is already here and authorized to work. It simply means that the employer cannot go further. And God forbid, if the employer is sanctioned by the Department of Labor, which could happen, the Department of Labor can even ban the employer from ever hiring a foreigner, depending on the reason for the denial. The next question. If an employer doesn't receive any application during the recruitment process, is that enough to prove no qualified U.S. workers are available? Oh yes. Oh yes. If the employer truly did not receive any application, that's what the application for labor certification will say. And if the Department of Labor decide to audit the employer, once the truth will always remain the truth. So if they audit the employer and realize that nobody applied, yeah. If nobody applied, there's nothing the employer can do other than to hire the one who is available, who is the foreigner. Yes, that doesn't have any negative impact. Next question. What should an employer do if the prevailing wage determination is higher than what they currently pay for similar role in their organization? Well, they will have to increase the salary because they will have to increase the offer. You see, let me tell you this. In the United States, this is one of the reasons why employers keep one employee information from another. There are employers who don't pay the same salary for the same position. There are employers who may have, maybe they have 3 lawyers and they are paying one 200,000. They are paying another one 80,000. They are paying one. So everybody, employee is dealt with on a one-on-one basis. So the employer will have to determine in this case, okay, this amount that the Department of Labor specify, can I afford to pay it for this foreigner? If the answer is no, then they suspend the process. They don't go further. That is why the prevailing wage determination is the first step before you even start placing any advert. So once you know that the figure that the Department of Labor came back with, you cannot meet it, then the employer has to stop. They can't do anything further. The next question. What happens after the labor certification is approved? Well, I already answered that before. Once the labor certification is approved, then the employer starts the process of the green card application on behalf of the foreigner. That is when the employer will now submit Form I-140, Immigrant Petition for Alien Worker. That is when the employer will go through that process. If the beneficiary is in the United States and visa is current, then the employer can apply for green card for this person. If the beneficiary is outside the United States or visa is not current, the employer will only be able to file for Form I-140, Immigrant Petition for Alien Worker, and then wait until visa becomes current to proceed with the processing. The next question. Is labor certification possible for part-time jobs, or does the prevailing wage process only apply to full-time roles? I believe it only applies to full-time roles because I think there is a requirement of minimum of 36 hours per week for a labor certification to be approved. So that would translate to a full-time role. Part-time is not going to be approved. The next question. If an employee has 2 potential employers willing to sponsor them, can they pursue labor certification with both employees simultaneously? Oh yes, there is no law that says you must send only one application to one employer. No, yeah, they can start that. If you have multiple employees, yes, you can apply to multiple employees, and you can apply to multiple employers. And of course, the employers may may start labor certification independently. And of course, whichever comes out good or whichever comes out first. Or even you can choose to wait for the employer you want to work with. Yes, multiple applications can be submitted. He has not. The most important thing, let me say this, the most important thing in this process is that the job offer must be good faith offer. It must be a legitimate offer. It cannot be an arranged job. It must be a legitimate job offer. That is the requirement. The next question: is concurrent filing of Form I-485 adjustment of status possible? Not with labor certification. You can't file concurrently with labor certification. No, that's not possible. You have to do labor certification process first. Remember, I-140, I-485, all those things are processed by USCIS. They are not processed by the Department of Labor. The Department of Labor is only concerned with labor certification, so you can't do it concurrently. You have to deal with the Department of Labor first, get it approved before you can start the process with immigration. With immigration, if visa is current, you can file I-140 and 485 concurrently. But with labor certification, no, you cannot file it concurrently. The next question: in tech roles requiring highly specific skill, how does an employer prove that US workers don't meet the qualifications? That's very simple. Place the advertisement, list the job requirement, and if people apply and you believe that they don't meet the requirement, you document it. When you apply for application for labor certification, if the employer is audited, what the Department of Labor is going to do, they are going to look at the industry. They are going to make a determination. Is this common within the industry? Let me give you an example. I remember some years back, we have this religious organization that I represented in filing for one of their employees. The employee was into IT. So we submitted this application, and then USCIS raised a question that, look, this is not common in the industry. This is a religious organization. Religious organizations don't hire this type of people. So they raised questions about it. We try to defend it that, look, every organization, including religious organizations, are computerizing their system now. So everybody needs IT expert and this and this. But the application was denied. They said, no, they are not buying it. It is not common in the industry. They know a lot of religious organizations. None of them are employing people for this type of position. That this is a position that is for secular employers, not for religious employers. So all these things are taken into consideration. The next question: can a small business owner who is also a foreign worker sponsor themselves for a... No, I don't. Can a small business owner who is also a foreign worker sponsor themselves for a labor certification? No. Labor certification is not meant for self-sponsor. Again, I think I just even answered this question previously. I stated that the job position must be seen as bona fide. It must be in good faith. When you start a process of labor certification for the purpose of hiring yourself, how can you prove that that is good faith? There's no good faith. How are you going to be given the opportunity to hire yourself and then you will prefer to hire American? That's not possible. You are going to end up hiring yourself. So that's not going to be a good faith offer. So that is not allowed. The next question: what are the consequences if an employer exaggerates job requirements to deter US applicants? I already answered this at the beginning. the application will be denied, because if the Department of Labor finds out, and that is why I said that when an employer submits an application for labor certification, the Department of Labor is going to review it. And sometimes they can decide to audit the employer. When they audit the employer, they are going to ask questions. Okay, why do you believe that these Americans are not qualified for this job? Did you even consider them? Or did you already have a preconceived idea of hiring this particular? So they scrutinize it. That's the whole purpose. They will scrutinize it. Yes, they will know. So the consequence is that the application will be denied, the employer can be sanctioned, the employer can be fined, the employer can even be banned from ever hiring a foreigner. So there are so many things that the Department of Labor can do, and they have the authority to do a lot of these things. Next question. How long does the labor certification process last? Well, that depends on the employer. Normally, when you place advertisement, all these things can be done simultaneously by the employer. For example, going back to use the example of the law office, let's say the law office wants to hire a lawyer. We take that decision today. We contact Dallas Morning News, place an advertisement with them. We contact Texas Workforce Commission, place an advertisement with them. We go to our IT department. We tell them to place advertisement on our website. We contact the different online job search websites, maybe Indeed.com, maybe, I just don't want to mention some names. I don't want to give unnecessary promotion. So we contact all these people. We give them, we tell them we have a position. Please help us place advertisement. So all those things, you can do it simultaneously. But the one from the Department of Labor, the state workforce agency, which will be Texas Workforce Commission in the case of this law office, because we are located in Texas. In that case, the advertisement has to last for at least 45 days. So once you place all these other advertisements simultaneously, so at the end of the 45 days, you will know whether people are applying or not. Then, if people didn't apply at the end of the 45 days, then you place the notice of job offer. So you place that. The law requires that notice must be placed for at least 10 business days, not calendar days, business days. So that means if you look at 10 business days, that would be like 14 calendar days. So you do all that. After all of that is done, the employer has to wait another 30 days before the employer can now submit an application. So all things being equal, depending on the employer, the process can be, when I say the process, up to submission can be done in 3 months. However, the timeline for the Department of Labor to respond, that one is outside our control. That could take years. It could take months, depending on the Department of Labor. We don't have control over it. We cannot influence it. Like I said, it even depends on what they decide to do. If they decide to audit the employer, it may even take longer. So that is unpredictable. But the thing is, labor certification application, the date the application is submitted, that is also the prevailing wage. So, no, not the prevailing wage. That is also the priority date. Even though you have not commenced the application process with immigration, for the purpose of determining priority date, the date that the labor certification application is submitted is considered your priority date. So even if the process takes longer, whenever they finish, visa may have been available for the beneficiary to use to apply for green card immediately. The next question: what steps can the employee take to proactively support their employer during the labor certification process? The employee does not have a role in this. Like I said, this is meant for the employer to offer Americans the job first. let me say this. The employee's position is actually contradictory to the Department of Labor's position. The Department of Labor's position is that they want to encourage the employer to hire Americans. The employee's position is that you want to discourage the employer from hiring an American so that they can hire you. So at the end of the day, your positions are not similar. So the employee does not have any role in this at all. The next question: is there any way the labor certification process can be skipped? Well, I think I explained this before. Excuse me. My interpretation of this question, is there any way the labor certification process can be skipped? My interpretation of this question is that, is there any exception to the labor certification? Yes, there are exceptions, and I've stated them before, and I'm going to state it again. There are exceptions. EB1 is an exception. EB2, national interest waiver, you are actually telling immigration to waive this labor certification process for you. EB4, religious worker, is an exception. EB5, investors, is an exception. Nurses and physical therapy, Schedule A occupations, they are an exception. Yes, so there are so many exceptions to the process. If you fall into all these things, the only thing that is not exempt are skilled workers, professionals, accountant, engineer, architect, lawyer, doctor, whatever, and every profession except physical therapists and nurses and religious workers. Those are the only three professions that are exempt. For every other one, you have to go through it. But if you don't want to go through it, raise money, invest $500,000, apply for green card for you and your family, straight line, no complications, easy. The only thing, explain the source of the money. The source of the money must be legitimate and you must be able to explain the source of the money. The next question: how can employees manage the uncertainty when the labor certification process drags on for years, especially in retrogress green card categories? Yeah, I've answered this question. The employee has nothing to worry about because the date that the labor certification application is submitted, that is considered the priority date. So the date that you join the queue. So you are already on the queue. So it doesn't matter how long the process takes, you are already on the queue. So once the labor certification is approved, they go back to the date of submission of the labor certification application in order for you to know when to apply for green card. So you don't have anything to lose. Employees have nothing to lose. They are already on the queue the date the labor certification application is submitted. Next question. Good evening, sir. Please, what pathway is the best way for me to obtain a green card as a fashion designer? I have a valid visit visa. Thank you. Unfortunately, that is not the question we are discussing today. We are discussing labor certification application today. What I will advise you to do is go back to our previous videos, our previous podcast, look at the relevant topic that addresses the questions that you have, or go back to any of the question and answer session, the one that are free, that are open, that we allow every question. But today, we are limiting our position to our podcast to labor certification question. The reason we do that is very simple. Whenever people go to our YouTube channel or to our Facebook channel, we want people to be able to look at particular topic. Otherwise, if somebody need a question, if somebody have a question about labor certification, for example, and if there is no topic that addresses labor certification, that means they may have to listen to 10, 20, 50 videos before they can see a simple answer to a question they have on labor certification. But when we treat question topic by topic, if somebody has a question about asylum, for example, all they need to do is when they go to our channel, which one is about asylum, they see it, they click on it, they listen to it. They don't need to watch labor certification before they can see asylum topic. So we want people to be able to see a specific topic, a specific need that they have. But once in a while, we also throw it open. We do general questions. I believe we did that a few weeks back. So go over the videos that may address this thing. But for today, we are addressing labor certification application so that whenever people are looking for answers to questions about labor certification, they click on this video, they will be able to see answers to all their questions. The next question: Can illegal overstayer convert to status and green card if he apply and get a job even after entry visa has expired? And 2, can asylum seeker convert to green card if they apply for a job and get it before asylum decision or after negative decision but not yet removed? Well, let me say this. I stated this at the beginning of this podcast. Labor certification only affects employment-based applications. When we are talking about green card, there are different ways to apply for green card. We have family-based, we have employment-based, and we have some special circumstances, which is where asylum fall into. So, but labor certification only affects employment-based. It doesn't affect family and it doesn't affect asylum. Now, if you apply for labor certification and you are approved, you still have to show that you are maintaining legal status. Every employment-based petition requires that the beneficiary is maintaining legal status. So if you are already out of status, this will not be beneficial to you. It only affects people who are maintaining legal status. Every employment base, that is their requirement, except you are eligible for 245I, which is a long shot. That means an immigrant petition or labor certification must have been filed on your behalf before April 30th, 2001. Except you meet that requirement, everybody applying for employment-based green card in the United States must show evidence that they are maintaining legal status. I believe that is the last question we have for today. It's already past our time. Do I have any unanswered questions? Okay, that is it for today. So again, remember to invite your family, friends, colleagues at work. We hope to see you again next week. We do this 12 p.m. Central Standard Time. That is 1 p.m. Eastern. That is 10 a.m. Pacific. And currently, that is 7 p.m. Nigerian time. Hope to see you again next week. God bless you.